afternoon and welcome to the thorough newspaper analysis brought to you by LawSikho for the 11th of July 2023. Now, today we will be having one editorial article which has been taken from the Indian Express, and it talks about the challenge to Jammu and Kashmir changes, which of course we know as the abrogation of Article 370. For the second and third segment of the day, we will have the news updates and the legal. The challenge to the Jammu and Kashmir changes. It talks about the Supreme Court's recent starting of hearing the matter of abrogation of Article 370 and lowering the status of Jammu and Kashmir into two union territories. Now, this is because the petitions involving important legal and constitutional questions will now be taken up by our Chief Justice of India, Justice D.Y. Chandrachud, and will also comprise the bench will also comprise of Justices Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice B.R. Gavai, and Justice Surya Kant. So, before we move on to that, first we have to understand what is the situation that has happened and what is the situation at present and what led to this situation. So, firstly, in 2018, on the 19th of June, governor's rule was imposed in Jammu and Kashmir. And this happened after the BJP withdrew their support to the coalition government that was being led by Chief Minister Mehbooba Mufti. Now, under Article 92 of the Jammu and Kashmir Constitution, 6 months of governor's rule was mandatory before the state could be put under the president's rule. Now, the Legislative Assembly, since the support had been withdrawn, the Legislative Assembly was dissolved on the 21st of November. And on the 12th of December, before the end of 6 months, President's rule was imposed on Jammu and Kashmir. President's rule was subsequently approved by both the houses of the parliament. And on the 12th of June 2019, which is almost after a year since the governor's rule being initiated, the president's rule was extended for another 6 months from the July 3rd of that year. Now, along with this, a slew of constitutional changes were also brought forward. Firstly, on the 5th of August, the Centre issued an order that amended the Constitution application to Jammu and Kashmir Order of 1954 and superseded it with the Constitution application to Jammu and Kashmir Order 2019. Now, what primarily this did was that it enforced all the provisions in the constitutions on Jammu and Kashmir state. The government also amended Article 367 with a new clause that made Constitution of India directly applicable to the Jammu and Kashmir. The president also decided to give a declaration under Article 370, Clause 3, making all its clauses inoperative except the provision that all articles of the Constitution would apply to Jammu and Kashmir. Now, the obvious question that arises from here is that what is this Article 370 that has been the subject of so much bloodshed, so much of legal battles? Now, Article 370 provided for the application of only Article 1 and Article 370 to the state of Jammu and Kashmir. Other provisions of the Constitution did not automatically extend to the Jammu and Kashmir. However, Article 370, subclause 1b, empowered the President of India to extend them to Jammu and Kashmir. However, in order to do so, via an executive order, it had to be done so with the concurrence of the government of Jammu and Kashmir. Now, Article 370, Clause 3 empowered the President to declare that this article shall cease to be operative, completely or partially, but this could only happen if the Constituent Assembly of Jammu and Kashmir had recommended such an action and if they had concurred on the same. Now, what happened is that back in 1957, the entirety of Constituent Assembly was removed and it no longer existed after that. Hence, by that logic, the extension of this power to the president also ceased until a new Constituent Assembly came into being. Now, Article 370 explains that the purpose of this article is that the state government of the Maharaja, which was later on changed to Sadr-e-Riyasat of Jammu and Kashmir, acting on the advice of the Council of Ministers. But of the period with regards to which we are talking about in this article, we need to note that there was no state government either in Jammu and Kashmir during this period. So the president again had no way to acquire the concurrence of the state government. This meant that the constitutional mechanism available to the center to abrogate or amend Article 370 technically does not exist. However, the center used the president's power under Article 371D to amend Article 367, which provides guidelines to interpret the Constitution. Now, a new clause was also added as we were discussing, replacing the Constituent Assembly of the state, referred to under 370 Clause 3, by the Legislative Assembly of the state. Thus, the presidential order route under Article 370, subclause 1, clause 1, subclause D, was used to amend Article 370 itself, whereas Article 370 could have been amended only upon the recommendation of the Constituent Assembly under Article 370, Clause 3, and not through Article 370, Clause 1, subclause D. Now, the question is, this brings forward a lot of colorable legislation because now, as we know, the doctrine of colorable legislation states that if there is something that you cannot do directly, legally, then you can't resort to indirect means to achieve that goal either. However, the center has done this allegedly, and this is the main crux of the matter that the Supreme Court will hear. Now, the president, while imposing his direct rule in Jammu and Kashmir, had assumed all the functions of Jammu and Kashmir government, taken all over the powers of the governor under both Indian Constitution and Jammu and Kashmir Constitution. Now, this is being touted as a phenomenon in which the President of India was in effect the Jammu and Kashmir state government, and the parliament was in effect the state legislature. The powers of the Jammu and Kashmir Constituent Assembly were passed on to the state legislature. And in this scheme of things, when the state government gave its concurrence to the monumental changes, it was actually, in fact, the president agreeing to his own decision. Because right now, according to this argument, he is not only the president, but he's also the state government. So it is him agreeing to his own decision. It has also been argued that since the president's rule in a state is in the nature of an interim, I'm sorry, is in the nature of an interim arrangement until an elected government is put in place, this entire administration of the president's rule cannot be used to take decisions that change the very constitutional structure of the state. Now, the Jammu and Kashmir Reorganization Act of 2019, which is the particular act that bifurcated the Jammu and Kashmir and demoted it from a state to a union territory with a legislative assembly, and Ladakh without an assembly. But there is no instance in India's entire constitutional history of a state being demoted to a union territory. Even though Parliament can, under Article 3, create a new state by carving out territory. Now, the center's entirety of this decision has been challenged on the ground that first, it violates Article 3. Secondly, the proviso to this article makes it incumbent on the president to refer any bills proposing the reorganization of a state to its legislature if the bill affects the area, boundaries, or the name of any of the states. It is argued that the view of the parliament on such a bill cannot replace the view of the state legislature. And under the president's rule, the powers of the state legislatures can be exercised only on the basis of an essential day-to-day affairs of the state. The parliament cannot provide a view of the particular state legislature, which in essence is the opinion of the people of the state. Now, the challenge is, as I was saying, is also based on the argument of the constitutional changes of colorable legislation and thus legally untenable. Now, the doctrine of colorable legislation, as we were discussing previously, states that what cannot be done directly cannot be done indirectly. And what is of interest here is that this doctrine has been reiterated time and again by the Supreme Court as well as other constitutional courts in this country and in other countries. So we are waiting to see how the Supreme Court goes forward with this and whether they actually agree with the charges that are being labeled against the state government, I'm sorry, the central government, or whether the apex court of the country goes forward with a clean sheet for the central government. Now, with regards to the national news for the day, we have Numaligarh refinery upgraded to Schedule A of CPSE. Numaligarh Refinery Limited has been upgraded from Schedule B of CPSE to Schedule A of CPSE. Now, the question is, what is a CPSE? A CPSE basically means Central Public Sector Enterprises. And all CPSEs are required to be categorized into four schedules, namely Schedule A, B, C, and D. The categorization of CPSE has implications mainly for organizational structure and salary of board level incumbents of the concerned CPSE. Now, this in particular, the promotion from Schedule B to Schedule A is a significant milestone for NRL. The upgradation to Schedule A was notified by the Ministry of Petroleum and Natural Gas on the 4th of July 2023. This upgradation recognizes NRL's strong financial performance and operational efficiency and contribution to the economic development of the Northeast region. Secondly, we have K. Rajaraman named IFSCA Chairman. K. Rajaraman, Secretary, Department of Telecommunications, will be the next chairman of the International Financial Services Centers Authority, or IFSCA, the Department of Personnel and Trading said in a notification. Rajaraman will succeed Injati Srinivas, who became the first chairman of the IFSCA in July 2020. Thirdly, we have Voyager Space Science move with NewSpace India Limited, or NSIL. Under this Memorandum of Understanding, Voyager Space and NSIL, which is the commercial arm of ISRO, will explore launch and deployment opportunities for small satellites orbited by Small Satellite Launch Vehicle and Polar Satellite Launch Vehicle. The two organizations will also study the use of space qualified components from NSIL in support of spacecraft manufacturing, deployment, operations, and other areas of interest. ISRO's state of the art launch infrastructure and NSIL's experience in delivering payloads to orbit expands access to space for Voyager's global customer base. Voyager Space has previously flown customer satellites on two PSLV missions. Next up, we have in a rather interesting development, Sangam-age stud bead unearthed in Tamil Nadu. A gold stud, a bone point, and a carnelian bead have been unearthed by archaeologists at Porpanai Kottai in Pudukottai district of Tamil Nadu, where the State of Archaeology Department has taken up excavations this year. A Sangam-age fort is believed to have existed at this site. Now, the Sangam age is the period from the 3rd century BC to the 3rd century AD in South India. There were three Sangams conducted in ancient South India called the Muchangam, Tamil legends say. These Sangams prospered under the royal patronage of the Pandya kings of Madurai. Next up, we have Atal Innovation Mission launches ATL Industry Visit. The Atal Innovation Mission, in collaboration with Bayer, launched a unique industry visit initiative under Atal Tinkering Labs at Bayer's manufacturing facility in Vapi, Gujarat. With AIM embarking on an ambitious program for industry exposure of students, Bayer has been working closely with AIM to be the foremost industry partner in this program. Bayer has opened its manufacturing and production plants and research centers across Vapi, Shamipet, Chandippa, and Bangalore to the ATL students to provide first-hand exposure to experience how technology, automation, and innovation are leveraged by the industry. Next up, we have India-Japan Navy's 6-day war game of Visakhapatnam concludes. The Indian and Japanese navies kicked off a 6-day war game of Visakhapatnam to further expand their overall military cooperation. The Indian Navy is hosting the 7th edition of the Japan-India Maritime Exercise JIMEX, and this edition marks the 11th anniversary of the war game since its inception in 2012. The Indian Navy has deployed India's first indigenously built guided missile destroyer, INS Delhi, indigenously built anti-submarine warfare corvette, INS Kamorta, fleet tanker, INS Shakti, a submarine, maritime pistol aircraft P-81, and shipborne helicopters and fighter aircraft for the exercise, according to the officials. Now, in the international news segment of the day, we have the Dutch government collapses. The Dutch government collapsed on the 7th of July, which was a Friday, after the parties in its ruling coalition failed to reach an agreement on migration policy, underlining how the issue of asylum seekers coming to Europe continues to divide governments across the continent. Prime Minister Mark Rutte, who was overseeing his fourth cabinet and is one of the Europe's longest serving leaders, told reporters on Friday that he would submit his resignation to the king. Secondly, we have New Zealand Prime Minister Hipkins signs an ambitious trade deal. New Zealand Prime Minister Hipkins has signed a very ambitious trade deal with the EU, but the EU retained the use of quotas for some Kiwi dairy products, beef and sheep meat, ethanol, and sweet corn. It is said that New Zealand will not be allowed to export more than 10,000 tons or 0.15% of the amount of beef the EU consumes, tariff free. The EU said that for butter, cheeses, and milk powder, the New Zealand could only export 0.71%, 0.27%, and 1.3% of the EU total consumption, respectively, before tariffs were levied to make them more expensive against EU produced goods. Thirdly, we have China releases its first open source computer operating system. China has released its first homegrown open source desktop operating system named Untitled as the country steps up efforts to cut reliance on US technology. Based on the existing open source Linux operating system, China's version was built by a community of about 4,000 developers and is used in space program and industries such as finance and energy. Developing an operating system independent of US technology has been an important goal of the tech industry of China in recent years, with many companies and organizations having contributed to the development of this particular open Kylian system. Fourthly, we also have the James Webb Telescope finds the most distant supermassive black hole. The most distant active supermassive black hole ever found just over 570 million years after the Big Bang. It is on the smaller side, more similar to the mass of the supermassive black hole at the center of our Milky Way galaxy. CEERS, or the CEERS researchers, also identified two more black holes in the early universe, along with almost a dozen extremely distant galaxies. Webb also identified 11 galaxies that existed when the universe was 470 to 675 million years old. We also have Justine Henin receives the Philippe Chatrier Award. The International Tennis Federation has awarded Justine Henin its highest honor, the Philippe Chatrier Award. Henin won 7 Grand Slam singles titles, an Olympic gold medal, and was part of Belgium's team that won the Fed Cup, now called the Billie Jean King Cup, in 2001. The award, named after the former ITF president, was introduced in 1996 and recognizes people who have made significant contributions to the sport on and off the court. Lastly, for the legal update segment of today, we have anticipatory bail. Personal liberty important, but courts must also consider gravity of offense and impact on society. Now, the Supreme Court in the case of Pratibha Machanda versus the state of Haryana observed that while dealing with anticipatory bail applications, courts must also consider the gravity of the offense, the impact on society, and the need for a fair and free investigation. While it is extremely important to protect the personal liberty of a person, it is equally incumbent to analyze the seriousness of the offense and determine if there is a need for custodial interrogation. The benches of Justice Suryakant and C.T. Ravikumar said. So this was all for today. For pre-study materials and TNA PDF slides, please join our Telegram channel, the link of which you can find in the description, or you can scan the barcode that is given on your screen. Don't forget to subscribe us on YouTube so that you can stay up to date with the thorough newspaper analysis as it comes up every day. Thank you.